So good afternoon, everyone, and welcome to part 2 of the session on copyright and photography. So as promised, today we will look at more closely at ownership issues. So before we get into that though, I would like to just take a step back to one of the issues which was raised. So there were some questions asked, and I did a little research. I was honestly really busy, but I just wanted to at least address some of the queries raised that I promised to get back to. So this issue of buildings in the public, I've inserted the section here. I will provide a copy of the PowerPoint to you. So section 73, which deals, that part of the law deals with exceptions. And it allows, this section specifically, applies to buildings, sculptures, models of buildings, and works of artistic craftsmanship, if permanently situated in a public place, or importantly, on premises open to the public. So in those situations, copyright in the work, because you have to remember there's architectural works have copyright as well. But anyway, the copyright in the works are not infringed by making a photograph or film of it. So as long as it is permanently situated in the public and is open, because the question came up, I think, last week, gated community, I believe, or property and the manager giving permission. So if permission is granted, yes, for private property, but as long as it's open to the public and it's a permanent fixture, you can take photos. There were some other points. I just wrote them down and I will read through them. When I provided PowerPoint, I'll include them as an attachment. So I looked at our legislation, and I looked at the UK legislation because originally that's the basis of our copyright legislation. I also started to do a little research on the question of drones, but from what I could see, there are some requirements in terms of how high and low you can go with the drone. But besides that, I couldn't find any specific provisions concerning privacy and copyright and so on. So I'm going to assume that the same laws apply if you're in a drone or if you're in a car or if you're walking by. Anyway, some of the points raised are not specifically addressed in the legislation, and sometimes you have to have case law in order to have an interpretation. So anyway, let me read through quickly so we can move on. So in terms of the issue of privacy, an individual has certain rights to control the use of their image. The specific details will vary from one country to another depending on national legislation. If you intend to sell or distribute images that include people, then it is worth getting your subjects to sign a model release form, as this will protect you against any comeback. And we discussed that last week. You have the right to keep any photographs you take unless confiscated via a warrant. You do not need permission from your subject to take their photograph. We discussed that last week as well. You own the copyright to any photographs you take, not the subject. And that would come up, say if you take a photo of a sculpture that is permanently situated in the public, obviously you own the photo, but you don't have any copyright in the sculpture itself. You may not, this is the point we just raised, you may not take photographs in a private establishment without permission. Although you are perfectly within your rights to take photographs from a public place, and the challenge sometimes is to understand or to distinguish what is public and what is private. There are examples. For example, pavements. Pavements might be considered private property, or pavements outside of private buildings. We have premises like shopping centers. Those are more than likely going to be considered as private. So sometimes it can get a little, hazy as to where the line is drawn. Then I have here, I will provide these though when I give you the attachment, just some questions or some comments that can come up. Things like, for example, you have no right to take a photo of me or my child. By law, you can take a photo of anyone from any public place. And that's subject to things, as I told you before, like, protection of children and so on. But if you're in a bar, for example, you would need to have permission from the owner of the bar to take photos in the bar, the people there. At any rate, I advise that you try to use a release form whenever possible. So that was just a summary of some of the issues raised last week. Now we will go on to the key parts, the key subject for today, which is the ownership of copyright. So if you remember last week, I advised that generally the author is the first owner of copyright. So the person who took the photograph. In the case of an employment situation, the employer owns the copyrights in works created by employees. And I think I mentioned this briefly last week. Now you have to be a little careful here, because if you are employed to take photos, this is clear. If you are employed as the receptionist, it is not so clear because you weren't employed to take photos. One second, I need to admit something. Okay. So you also have to look at the job description and so on. And this is not just to do with photos. This is generally in IP, in intellectual property law. The standard rule is that the employer will be the owner, the first owner, not the author, but the owner. But you do have to check things like what was the person employed to do. And if you take photos that the firm, the company uses, say, on their website, and you're the receptionist, then you have a right to negotiate payment or terms of use, etc., because that was not what you were employed to do. So I remember touching on this last week as well, the issue of freelance workers. And I think I gave the example of those who work in the media. So as you probably know, a freelance worker is not the same as an employee. You're going to have a You're going to have a contract, and you will need to be very clear about the scope of that contract. When you take, sorry, the photos, okay, when you take the photos, what are the terms and conditions? So are you providing them photos to use permanently in across all media? So in the actual newspaper, online, social media, etc. Are you limiting the number of uses? Are you given a right to edit, to make those changes, etc.? So you need to be clear about those types of terms and conditions in the contract. And I mentioned the point of, this question of ownership and where you may set up a firm and a company, and the risk of, the rights being owned by the company and then could be subject to transfer. I don't know how many of you are set up like that, but it's just something to always bear in mind. So the commissioned work. So what our legislation says is that the person who commissions the work is the first owner of copyright. And that can get a little tricky. So someone commissions you, an artist, a photographer, to create or produce a new piece of work. And that is what you would consider commissioning. So if you take, if someone hires you to take photos at a wedding, for example. So the law says the first owner is the person who is commissioning. And that is, you have to be careful when you're, I know you'll talk with persons from, sorry, I'm trying to let in someone. It's harder than it should be. Okay. When you talk to persons from other jurisdictions, you have to be really careful about this. Because, for example, in the UK, the law used to read like this, and they changed it. It's now the exact opposite. So you need to be careful and be aware of what the legislation says. So as soon as the work comes into existence, even if it is, even if it's not yet completed, copyright will, the copyright will vest with the commissioner at that point.
Excuse me.
Yes?
Great question. Can that not be negotiated within the contract with commission work? So specifically in the contract, if you state that the photographer is the rights owner or the copyright owner, and that's
we're getting there. We're getting there.
Okay.
We're getting there. So what amounts to commissioning? It means to order. So it is an actual creation of an obligation to create on the one hand and to pay. And it should happen before the work is actually created. So you're sitting in your office and someone comes they've made a very clear and specific order for you to do some photography. It doesn't happen after the fact. After the fact, you're just selling the work or licensing it or whatever you want to do. So I gave the example here of a professional photographer. In this situation, was there an agreement to pay? This is where you might go to an event and take photos and then try to get people to buy the copies. In that situation, you were obviously not commissioned to do the work. So you, straight off the bat, you retain the copyright in your work. One second. Okay. No, this is where I think it was Hugh. This is where the whole issue of how you can vary that comes into mind. And I mentioned it last week. So you have certain rights established by the Copyright Act, but the exercise of those rights can be varied by contract. So this question, what was the payment for? And here it distinguishes between were you paying for the prints or copies? Did you agree to sell the negatives? You could still sell the negatives and still keep the copyright. All of that is possible. So you need to be clear, and I know, or I suspect most people don't do it in practice, but you should be very, very clear about what the client is paying for. So if you want to retain the copyright in the work, your agreement should clearly state that you retain, or the copyright, because you can't say retain, but that the copyright is transferred to you, the photographer, because it has to be transferred to you, because remember, with a commission work, the commissioner is the first owner. So the client is the first owner. So you have to be clear with them. If you want me to take these photos and you want that, there's no transfer of the copyright, then instead of paying $50, you pay $300. You can have it in a very basic, terms of use. So it doesn't have to be a big fancy agreement. You can have your terms and conditions for contracting. And you say, this is how I work. And for any work I'm commissioned to do on, the agreement will be that the copyright is transferred to me, the photographer, unless the parties agree otherwise. So far, so good?
Another question. Thank you very much for another question. And this just, I guess, for clarification. How do you then take in consideration a wedding photographer? Is that a commission? Right.
So I have to admit, I don't really know anything about weddings or wedding photography. But I give the example of where now the bride and groom may want to have photos taken. So they will contract your services for their photos. Whilst you're at the wedding, and I really have no experience with this, but unless there's a clear agreement that they're responsible and they're contracting you to take photos, you know, you take photos of everybody who's there and all that, then that could be captured under the agreement with the bride and groom. If the agreement is that you can take photos of them, but you can also take photos of the guests, and then, you know, have your private arrangements with the guest. In that scenario, they wouldn't be commissioned works. There would be a case of you taking photos and offering them for sale.
Okay.
But-
Because yeah, I understand that part. But what was unclear to me is if the actual act of working for the bride and groom or for the bride and groom's parents or in-laws or whoever, is that the act of a commission? In other words, you've been asked or paid.
I would assume it is a commission. I assume that the bride or groom or whoever contracts with you to come and take the photos.
Right.
So there's a obligation on your part to do something, and they're then obliged to pay you, right?
Correct.
That's how it works. So it's a commissioned work.
Right. Which is very important from what you said before.
Yeah, and in that scenario,
what you said before.
yeah, and you need to be very clear, or you need to at least have terms of use, or terms of contracting that you provide to these clients. I think a lot of people assume that they've hired you to take the photos and they're theirs and the rights are theirs. And they're correct. They're correct unless you have some sort of agreement that says otherwise. And from the little I know, this is a source of contention, and you can clarify by having terms of use or standard type of contract or something. The one issue it raises for me, and I don't know how photographers practice their trade in Barbados, but in attempting to clarify that situation with the public, I suspect the issue you may have is establishing value, meaning how much do you're commissioned to take works at photos at a wedding. I don't know what the standard price range is out there. And I don't know if that price range is based on an understanding of, say, the photographer keeping the copyright. But let's say there's a practice of charging $1,500 for a wedding, and the photographer's position is the copyright belongs to me. I'm not giving them the negatives either. If they want copies, they gotta come back. And we assume none of that is really in writing or anything, but that's the standard practice. Now, if you decide, look, I want to make sure I have everything, I want everything set up straight, I don't want to have no issues, so I will make sure and start letting people know my terms and conditions and get them to sign and agreeing to that. And say if they want to have the copyright, instead of paying me $1,500, they will pay $2,500. I think you photographers will have to know the impact that will have. Will it mean that, for example, some photographers might say, man, they could get the copyright for the $1,500? Or is there a general industry understanding about the types of rates to be charged? That's the major issue I could see arising. having a value to the full, the transfer of copyright.
Question.
Mhm,
Let us suppose that there was one situation where a good friend of mine's daughter was getting married.
mhm,
At that time, they were living abroad, and they had contracted a photographer, blah blah blah, to do the work. And I called the mother and asked if she wanted me to take some pictures also. I wasn't charging her or anything like this. There was no signed document. So I took the pictures, I gave them the work. Who owns the copyright in that sort of case?
Sorry, you offer to take
Yeah,
the photos,
I
right?
offered to take the pictures.
Yeah, in that case, I would think you retain the copyright.
Okay.
So, I guess in a later session, when you've given it some thought, we could have a conversation on how, the industry practices this kind of thing. And if you can see a scenario where you can move to being a bit more formalized. Do any of you already use written agreements?
I have only used written agreements with models,
Okay,
but I've never used it with weddings.
okay. Anyone else?
I use written agreements for weddings.
Okay, okay. Well, just remember that our law says the rights belong to the commissioner first. And therefore, depending on what you want to achieve, you may have to look at having the rights transferred to you. And you can vary it according to the fees charged and so on. All right.
Before we move on, perhaps at the end of all the sessions, we could come up with some sort of template agreement, template model release that we could use, that the club and the members can use to try to get it standardized among most of the photographers and know exactly what we're saying and what we'll be getting.
Maybe I can look for some sort of standard agreement for you. I said maybe. I don't mind helping, but it depends on, it depends on how much this turns out to be.
Yeah.
But I can commit to getting something for you to start with at any rate.
Yeah.
I'm a little hesitant. Let me tell you honestly, as you would know, I work with artists in terms of music. And I don't know how your group is, but I get enough challenges working with groups. So I will see how much I can help.
Yeah.
I hope that it's an easier process than working with other groups.
But what we have done in the past through Barbados Photographic Society is if they arrange a model shoot and brought in the models, then sometimes they would provide a model release form for them to sign and re-sign. So whoever is at that shoot would have the agreement there.
That's fine.
Outside of that, if it is myself and I doing my own model release, I got something off in the net and tweeted it to suit myself, but I might miss out some important features. That's why you could probably get a guide.
But you have the model releases, but then especially for those who do commercial work, you'll also have to have something that speaks to the conditions under which you work. So to my mind, you have to have the model release, but you need something else. And it doesn't have to be like some sort of equal contract. It could be done up as a, like I said, terms and conditions for contracting, and a little one pager, and you have people sign off. But I don't mind us after we get through the substantive part of this, you know, discussing those and looking at some templates. All right, so we spoke about when you're employed and the need to be very clear about your job description. So the situation where you're employed to take photos, whether as your substantive task or as part of your job, and where you are a freelancer, including when you're commissioned to do works. Now, once you are the copyright holder, and I keep emphasizing, the photographer, the author, isn't necessarily always the copyright holder because of what I just spoke about, commissioned works and so on. But generally, and going back to what we looked at in the first session, the copyright holder has a number of exclusive economic rights, and you need permission if you're going to exploit any of those rights, including copying, where you're copying the work. And specifically as it relates to the copying of the work, there are situations where this can be done without first having the copyright holder's permission. And this is where you talk about fair dealing. Now, in the US, they talk about fair use. And it's a very similar concept. It's just that under the British the British tradition, fair dealing, they would specify all the different situations in which fair dealing applies. Fair use is just very broadly stated, but they essentially seek to achieve the same thing. They limit your ability to exercise your rights in copyright. So most of us are maybe familiar with the fact that you can do criticisms and reviews of other works or performances of other works without seeking permission from the rights holder, from the copyright holder. So if you're doing a review of a play, or, you know, there's an exhibition of works, you don't need permission to do that review, that criticism, and to refer to copies of the work. The other scenario is with, no, be careful here, the reporting of current events. But the exception does not include photographs under our legislation. So for the purpose of reporting current events, you can use a protected work, but not photographs. And I don't think a lot of people here understand that. You will need to have the permission of the copyright holder. Obviously, or I'm assuming, in the case of our newspapers, most times the assumption would be that they have some sort of agreement with the photographer to start with. But this, I think, becomes a little problematic, you know, if a current event is being reported and you take photos from another source and use it in your reporting, because our legislation does not allow that without permission. So I thought that, I think that's something that is really important for people to know, especially in this day of, you know, social media and so on. So you can get away with, for example, a song, a recording of a song. You know, they will do a new story about an event, and they may show you a bit of a performance or something. In that case, you know, the copyright law allows you to do that. But the other thing I should point out, even in that situation, is there's still limitations. And this is something, a problem I have with one of the local newspapers with their online stories. So back when we had events, they would basically record a whole number of performances at events, of the live performances, and then do, you know, a little write-up around it and call it reporting, and rely on this exception that says you can, you know, use the recordings of the performances for reporting. But in fact, I don't know that there's any case law here, but there's case law in many jurisdictions, and it's very clear that you can only use a snippet. So if you go and record an entire performance, you're going to have a problem. Anyway, that's not your concern. You're interested in photographs. And the point is, this exception does not apply to photographs. So someone cannot take up your photo or, you know, copy your photo and use it for news or current affairs program or something like that without your permission, assuming, of course, you do own the copyright, and claim that there's an exception. Okay, well, this is, these will not really apply to you. Here you have I think this came out last week, the incidental inclusion of an artistic work, and photos are artistic works. So where, you know, someone may be taken in an art gallery or somewhere, they take a photo and a copy of your work is somewhere in the background. It's just an what you call incidental inclusion. And you may, in that situation, fall under this exception, and it can be treated as fair dealing. Sorry, I just, in the chat, with Hans, I think with Hans, you should tell us your real name, but anyway, with Hans says, sometimes I cover events where photographers are asked to take video as well. The same thing will apply, the same concepts and principles apply to video. So you need to have, if you're also going to be taking video, same, you need to have in your agreement the terms and conditions there. So the principles I've been going through generally apply. The only real exception so far is what I just told you about there being no exception for the use of photographs in the reporting of current affairs or the news. But other than that, the principles apply generally.
Question. I'm also a member of the Barbados Arts Council. And
Okay.
they have a show,
Mhm.
and they want it covered. And what I've done in the past, when I was on the executive, is to take a picture of the wall, the different walls of the art. So we're having nearly every picture that is there. And then when they have the opening night, take pictures of the people who visit and of them watching the work and things like that. And they use it for their website and also to put it on Facebook to share the work to a wider audience in the hope too that people that didn't get to the show will either come and visit or see a picture that they might want to purchase. Now, do I have the right to do that, or I have to get written permission?
No, you need, you should, I don't know if you are, if you do the, I don't know your arrangement with the Arts Council. I don't know if they contract you to do those photos or what, but either you or the Arts Council, or maybe both, should seek to have permission from the copyright holders of the pieces you're taking the photos of. You would have something that says they agree to let you do it strictly for promotional purposes.
Right.
And if you have to guarantee that you use I'm no photographer, but when you don't use high resolution, that you'll take res photos or what have you. But yeah, you need permission for that.
Okay.
So just to be clear, when you say the Arts, you remember the Arts Council as a photographer, or you're also doing painting as well?
I don't paint. I don't. So I just do photography.
Okay.
Okay.
All right. The other instances of fair dealing. So this is where works are used in teaching, for the purpose of instruction. Copies can be made of the work and not just photos, not just artistic works, but other copyright protected works. For the purpose of instruction, education, but the copying has to be done by the student or the teacher, and it cannot be by means of a reprographic process, meaning photocopying. And I must say that I believe recommendations were made to change this because it makes no sense from a technological perspective. But this exception goes a little further because, as you may know, there is a society here called B-Copy. I believe the chairman it's Antonio Burrada. And they administer the rights in literary and graphic arts in terms of reprographic processes. So what all that means is, if you say are an educational institution and you're going to have high levels of photocopying taking place, it could be of books, it could be of other graphic materials, including photographs. The institution is supposed to have a license from B-Copy on behalf of the entities and persons it represents. And how it works is the university, for example, will pay a license fee, and there's some accounting of the works that have been copied and used, and royalties are paid. So the law provides some exceptions in terms of copying, but there are some limits. So I don't know them offhand, but things like you can't copy more than 5% of one chapter of a book. And there are different limitations. And once you go over those allowances, you really should have a license. The general point being, if the work is being used for the purpose of instruction, usually it can be copied for that purpose. Let's not worry about that by means of graphic process, because like I said, technologically speaking, that's a very, that was inherited from very old legislation, and it needs to be changed.
Slight sidetrack. I also sing and belong to a choir, and we usually copy the work and use it to practice and perform. Is that a no-no, or what is the situation?
I don't know, honestly, if you would, I suspect that could be treated as in the course of instruction. I don't know how many copies and volume you're talking about, though, because as I told you, you have some limitations, but there are rules about volumes. So I am assuming, I may be assuming wrong, that we aren't talking about huge volumes of copying. But I am pretty sure you can treat it as in the course of instruction. Okay, I will check the quantities you're allowed to do, but I am almost sure that you're not infringing.
Thank you.
All right, I'm just noticing. All right, I think there's a question. Okay, so with Hans, it's Michael Lowe. Hello, Michael Lowe. So the whole performance would be recorded for the online newspaper to use in their reporting. Are you suggesting that it is wrong for the newspaper to use the whole clip, but it is public? Okay, let's just explain in terms of what happens with music briefly. So when a song is performed in public, oh, those are two questions? Sorry, I don't understand the questions. So, all right, let's go again. Question one, the whole performance will be recorded for the online newspaper to use in their reporting. Are you suggesting that it's wrong for the newspaper to use the whole clip? Depends on how long the clip is, essentially. If you use just a few seconds, it would not be an infringement. The principle is that you use only just the amount that is absolutely necessary for the reporting. And if in fact there is really no reason to use the clip, then it can be challenged. Certainly, if you use the whole performance, so the whole song, or you use multiple clips, multiple performances, I am telling you that it can be very, very easily challenged, right? So all they should use at the very most is a very few seconds of one of the performers. All right, and then the next question was for Dr. Mon. where you were saying, but asking if the copies for the choir will be made public. So Dr. Mon, I must admit, I assume the copies are strictly for the use of the
For the
choir to
choir,
practice.
yes, that's for the choir.
Yeah, if they were distributing to the public, Shondine, that would be another story altogether.
But the only problem with that is that having practice, use the copies for instruction and whatever, and we learn the copies, then at the end of the year, we have a performance for the public. But we haven't given the copies, we haven't given the copy things to the public, but we are still performing the music for the public.
Yeah, that's fine. I'm pretty sure the practice will be treated as in the course of instruction. The performance is another thing altogether. And I don't want to get into music. That's not the interest today, but what will happen is that you use the material to practice with in a non-commercial and limited way. And you didn't distribute further copies. Now, I am assuming it isn't that you took a book and photocopied the whole book. So this is why I made the qualification and said, I don't know the quantities you're talking about, but I am assuming maybe it is a song here, a song there. If your choir, Dr. Mon, is copying, a whole book, or the majority of a book, or very large quantities of a book, that would change the picture. But if you are taking a work, say from this book and another from that book, and you can get away with that.
No, we would normally purchase a book, or the whole set of books. What we normally will be copying is an individual music sheet for a song. But obviously, you have to copy the whole of the music sheet for the song, the one song.
Oh, so you buy a book, the choir buys one copy and then photocopy.
No. The book, we usually buy enough books for the choir. Under 30 books. But if it's one song, we get a copy of the music. Then we will use that and photocopy it for the choir to perform.
Okay.
I suppose to bring it back to the photography, if we're doing video copies of it, I don't know. Let me stick to
It's going to depend on the quantity. At the end of the day, it's going to depend on the quantity. So if I assume a very limited quantity, strictly for the purpose of instruction, then I believe you're safe. So I'm assuming it really is a large quantity. That is the underlying assumption in my response, okay?
Yes, thanks.
Someone had their hand raised.
Yes, please, that'll be me.
Yeah, I was looking. Okay.
Hi, good night.
Hello, good day.
I joined it a bit late. So I don't think I think I may have missed the section that I really wanted to hear about. So I don't mind if you mind answering my questions really quickly for me. In regards to copyright holder, I would just like you to briefly explain to me in Barbados, for a photographer, what exactly is the copyright holder?
Sorry, when exactly? Sorry, say the question again.
Sorry. Okay, so in regards to Barbados and photographers, and us doing, let's say, like a birthday shoot for somebody, like you want me to do your birthday shoot, Erica.
Yeah.
And I give you my rate and you pay my rate and I do your photos for you. Here, do I lose my copyright because you paid me for the shoot?
All right, we not too long spoke about that. So where you're commissioned to do a work, let me just take back the slides, I'll be quick. here. Under our legislation, if you are commissioned to do a work, so someone engages you to do something specific, take photos at a photo shoot, at a birthday party or something. The person who commissions you is the first owner of the copyright holder. Now, most photographers work on the basis that they own the copyright, and this is possible, but you have to have that agreement with the client. So someone commissions or contracts you to take photos at a birthday shoot, you want to ensure you own the copyright, you want to own the negatives, whatever, you need to have it clear in a contract. Now, I know whenever I say contract, people get a little nervous, and it does not mean a 10-page document necessarily. It could, but it doesn't have to be. You know how you've set up your business, you know the basis on which you charge. So you would just have something that says, you know, if you hire me to do photos at a photo shoot, all copyright will be transferred to me, Alexander Newton. If you want to retain ownership of the negatives, you will specify that. But the law says the client is the first holder of copyright, and therefore, if you want to be have a lot more certainty, I would advise you to have a little agreement in place. And what Dr. Marn has, I suppose, negotiated is that at the end of the sessions, we could try to have some simple model agreements that you can use. And I'm glad you asked the question.
Thank you. Because I mean, as well, in Barbados, most of us, I don't know about everybody, but for me, example, when I was learning about photography and just getting the camera and everything, we looked to overseas practitioners for advice and stuff. And it was said overseas, or it is said that the person who clicks the shutter on the camera owns the copyright regardless.
Yeah, I also advise that you are careful in this regard, because, for example, in the UK, their legislation many years ago was the same as, it read the same as ours, and they changed it. So you have to be careful when looking at what happens in other countries. You have to really know what the legislation says. So the UK says the opposite to ours, and France and some other countries. So you have to know what the local legislation says.
Perfectly, yes. I had no idea where to go. So I'm glad that Bradley got this started, because I think a lot of us needed to hear this.
There's another situation where I did some weddings for the Hilton.
Mm-hmm.
I understand is that the Hilton provided a service for the bride and groom, for the client, for their client, and then they approached me to come and take their pictures. So who owns the copyright? Is it the people's pictures, the people who, the bride and groom, the Hilton, or the photographer? Because there are three people involved now.
In that situation, you need to know the terms and of the agreement the Hilton has with the guest. If the Hiltons understand, I mean, you could talk to them if it's where they are just facilitating, because I wouldn't see that the Hilton would want any ownership, you know, in the work. So without knowing, I don't know if they do a formal agreement with the guests, or I don't know how they make the arrangements. But I would assume that they're really just facilitating. Again, I don't know if they charge the guests for this facilitation or whatever, but I will also assume that the Hilton has no interest in the ownership of the work.
Okay,
But the Hilton is the party commissioning you, because
Right.
your agreement is with the Hilton.
right, yeah,
So you have to be careful, because you can make an agreement with the Hilton and say that the copyright stays with me, I can sell them copies, but I own the negatives and copyright, or I could sell the negatives or whatever, but I own the copyright, whatever you want to agree. But it has to align with whatever arrangement they have with the guests,
right,
right? So if you know you're being engaged by the Hilton, you would have to make clear with them, this is your agreement. And I would also, I don't know how much, trust and so on there is in the process, but I would want that the guests themselves also sign off, so that they can't later argue they didn't know and all of that.
right. Okay, thank you.
All right, but the point I wanted to make, which I forgot to mention when I was doing the introduction, and it's very important. I don't know how it slipped me, but the transfer of copyright under our law should be in writing. So this thing about oral agreements, no. For the transfer of copyright, the assignment of copyright to another party, it should be in writing. So I strongly advise that you do use some simple form or standard agreement based on how you go about business or the arrangement you have in place, because the arrangement may vary from client to client. That the issue of the transfer of ownership is dealt with in writing, because our law actually says the transfer of copyright or the assignment of copyright has to be in writing. So please bear that in mind.
Thank you so much.
Yeah, you're welcome. So we were talking about situations where copies of the work can be used. So I'm gonna get this up. And there's no infringement. And I think there may be another comment in the chat. So Dr. Mon, for the latecomer, raised the question of where his choir does photos of a work to practice with, and whether that was possible. Now, the ability to do copies of a work, of a protected work, for the purpose of instruction or for education or whatever, is subject to some limitations based on quantities. So if I assume that Dr. Mon's choir is making only limited copies for the purpose of instruction, yes, they will perform the works later, but they're just copying for the purpose of instruction. They're not distributing copies, they're not selling copies. Then I believe that he can, there's not an issue. But I say that subject to not knowing, things like quantity and so on. The legislation actually says, so I will look and come back to you, Dr. And then Sean Dean said, or stated that, you know, you would also have to consider whether copies will be made public. True. And she says, I guess he would have a problem if he photocopied the song and distributed it in a program. Definitely then it would be a problem, Sean D. So if it's just for the instruction, okay, but you can be distributing it publicly and so on. Similarly, you can use copies of a work for the purpose of examination. So that is not an issue. Again, for the latecomer, there was one point raised in terms of videos. So I was saying that these principles are not specific to photographs. So the principles would generally also apply to videos. Not the one thing you need to check would be with all of the limitations and exceptions, all the things that fall under fair dealing. I can't give it a broad sweep because they're sometimes not applicable for all categories of works. But generally speaking, the principles, the same principles apply for videos. And the one other exception, I'm sorry, I'm going back to the rest of you, but I just want to make sure he's clear, is with the exception for reporting current events. And you can use protected works, copies of protected works for the purpose of reporting current events, except photographs. So the idea of taking someone's photograph and using it for a news item without their permission is a no-no. There is no exception for photographs in that situation. All right, let's move on. Now, yes, Alexander.
Real quickly, when you just said that, something occurred to me in my brain. I know that there's such a genre of photography called street photography, where people photograph people on the street in their everyday lives and use it as artwork. What legislation do we have in Barbados on that? Is it okay to go and Bridgetown and photograph people on the street?
Okay, so you weren't here at the very beginning.
No.
So I beg the other students' indulgence. Let me just quickly go back to the beginning of today's session. Oh, sorry, I read it. I didn't include it in the slide. So I made some notes that I'm going to give you along with the slide.
Oh, okay.
But last week, this whole issue came up and it ties in with privacy. But the point is, you can take photos of people in public without their permission, actually. Even if you're going to commercialize the work. But nonetheless, you're strongly recommended to use release forms. And then, yeah, you know, there are other things you have to be cautious about, like where the photos concern children and, you know, issues of protection of children and so on. But we don't have a limitation that prevents you from taking photos of persons in public.
Okay, got that.
Right?
That'd be very helpful.
Yes, but you know, I always there's the law, and then for me, there is always a need to be as ethical and as thoughtful as possible.
Agreed, agreed.
All right. Okay, so let me go back. Where was I? Okay, so and this actually came up. A lawyer, an attorney, a local attorney, he was really upset because I think he was being sued, and the other side were using copies of some works he had written, and he was really upset about that. But there's a limitation in the act that allows for that. So copyright in a work is not infringed by anything done for the purposes of parliamentary or judicial proceedings, or subject to limitations, certain limitations for the purposes of reporting such proceedings. So, you know, you have a case, it may reference to a copyright protected work, copies of the work, or other use of the work, you know, it can be performed or whatever in the court or in parliament, and it would not infringe copyright. And in turn, when you do your reporting of what took place in court or in parliament, and it says subject to certain limitations, and please don't ask me what those limitations are, because I would have to refer to the act. But I'm going to assume things like, again, if you have, you know, underage children involved, or certain things like state security and so on. Outside of those, you have these exceptions under fair dealing. And Alexander, I pointed out that in the UK, in Barbados, in a lot of Commonwealth jurisdictions, they would talk about fair dealing, meaning exceptions under which you can use a protected work without permission. And in the US, they talk of fair use. I think in Australia now they've changed it to fair use as well. And they're very similar concepts. So this is where your permission as the holder of copyright is not required to do certain things. Okay, in the last session, someone asked about where, you know, you use a photo to create another work. All right, so there's a concept of the derivative work. So where you take an existing work, and when I say work, it could be a photograph, it could be any copyright work. So it could be a book or a film or whatever, but where you take a work and you use it as the basis for a new work, that is a derivative work. It was derived from another work. And it's getting really complicated. And in the US, especially, there's a lot of case law being developed around this, because you have things like mashups, and then you creep into the world of samples and so on. It can be a really murky situation. And reminding you of what I told you last week, you can have two-dimensional copies. You could have a two-dimensional copy of a three-dimensional work, and a two-dimensional copy, and a three-dimensional copy of a two-dimensional work. So the copying isn't necessarily literal like a photocopy. It can be other forms of copy. So this case, you had this photograph of Barack Obama taken obviously yet many years ago. And then when he, was campaigning to become president, this poster, the Hope poster, was done and became very, very famous. And to put, as I understand the story, you had this Hope poster which became very popular, and people then started applying it to, mugs, T-shirts, and other uses. So the creator of the poster was then trying to exercise their rights with all of these people who were using the image from the poster to apply to all kinds of other things. But then it came out that the poster was in fact based on a photograph from years ago. And the creator of the poster tried to argue fair use of the photograph and to claim that basically they had created a new work out of it and this shouldn't be treated as an infringement. So eventually it was settled. It was a settlement case. But I just wanted to use it as an illustration. And someone raised a question about this type of situation in the last session. So there's a scenario where you take a photo, like where Dr. Mon mentioned taking the photo of some artistic works that are exhibited in an Art Council exhibition for use as promotion for the exhibition of the works. Now, you're taking a photo of something that is protected by copyright. Other than fair dealing, so all the exceptions we just went through, like education, for the purpose of court proceedings, it's for the purpose of criticism, and there are other actual exceptions. So for example, you can do copies for a library. So the National Library Service can do copies of literary works and not infringe copyright. But the point is, if you take a photo of a protected work, you need permission of the owner of that protected work. If not, you could very well be infringing their rights. But that doesn't stop there being copyright in the new work. So what could happen is you take a photo and infringe someone's copyright. They may then claim an interest in the new work. So they may, they threaten to sue you, and you want to have a settlement. And so in the case of the original photographer, so they can say that I'm going to sue you, you infringe my photo. And you as the creator of the posters, it's doing really well. You're licensing it out to all those people who want to put it on T-shirts and so on, because you're threatening them. So they all have licenses and they're all paying you royalties. You're making good money. And up comes the original photographer. The original photographer may say that you infringe my rights with that poster. You're making a lot of money off of it. You need to give me my share. So that's probably what the settlement agreement was, that the owner of the poster then had to share the royalties with the original photographer because he or she infringed the rights. So, sorry, go ahead.
Let us suppose, and going back to the Arts Council situation, you have the opening night, and then you have four artists posing, and they take their picture, and they're in focus, but you have these pictures behind, which are not the focus on the main study, but you can still see them and they may be slightly out of focus or what, will it still be infringing?
That might be treated as an incidental inclusion. Remember, one of the exceptions I mentioned was, did I put, yeah, here it is. What's wrong with this? Here, where there's an incidental inclusion. So it's not the main focus, it just was by the way, right? So the scenario you just painted, I would think it could be treated as an incidental inclusion and would not be the subject of infringement.
Thanks.
All right. There's, let me see what's in the chat. I am a graphic. All right, so this is Clarissa. Hi, I'm a graphic design tutor. How would this apply with the use of stock images? Let's see. And then design. Okay, now stock images bring out another situation. This thing about royalty-free photos. Now, just because it says royalty-free doesn't mean there's no copyright issue. I use, for example, Petzls.com quite a bit. And I have, anytime or Shutterstock or what, whenever I use those services, I look at the terms because they have different forms of licenses. So they may say, you know, you can use a photo of this size or this resolution for the purpose of teaching or for non-commercial use only. So assuming when you say stock images, you're talking about, you know, royalty-free photos, you need to know the terms of use. And it will stipulate how you can use and so on. And sometimes they will have a strict restriction on commercial use, or if you want to use commercially, or you want to use a certain resolution or a certain size or what have you, then it could be the subject of license fees. So even in the case of instruction, remember what I said earlier, there are exceptions for making copies, but these are subject to quantity restrictions. So if you are doing more than the law says, I'm sorry, I didn't think to follow, you know, the restriction, the quantities and so on. I'll give you that information in the next session. But if you are using more than a certain quantity, then you may find you need a license. But there are some sites that will allow you to use freely for non-commercial purposes, and then you're in the clear. So you should make sure and use services that allow for that broad use. But just remember, when you see these things saying copyright free, royalty free, you need to really read the terms carefully, because often, very often, there are certain restrictions, and it's not really free, it's free within certain restrictions. All right, so we looked at where a poster was made from the photo, but you could have the reverse, where a photo could have been made of the poster, in which case the photographer would have been infringing the right of the artist who did the poster. So as long as it's a work that is protected, the safest thing to do is to ask permission. And I can't remember if I said it in the first session or not, but I had a question in an online session a couple months ago. And to be clear, they asked me, suppose it's a photo from someone in, let's say in Guam, or some other country far, far away. And I had to be very clear that for copyright, we are parties to an international treaty called the Berne Convention. And almost every country on earth is party to the Berne Convention. And importantly, that convention says, your country will protect the authors from my country in your territory. So it's almost as, you could say that by having copyright, your copyright is respected globally. So unlike other forms of intellectual property, which are based strictly on territory. So you have to have registered in the territory to have protection. With copyright, remember, you don't have to register. And as long as the country is a party to the Berne Convention, and there are a few others, but the Berne is the largest and most established. And honestly, I think maybe the only country that I think is not a member of Berne might be Iran, and I'm not even so, or Iraq, I don't know. But there are like 186 members, I believe, or 180 something countries which are party to the Berne Convention. So it's almost as though you have copyright globally. So the principles apply whether you're talking about another Barbadian's work, or an Australian's work, or somebody from Russia's work. The rights have to respect it all the same.
A point, getting back to the poster. I was in Cuba a time back, and they had a poster of Che. But this poster was, some parts were faded and discolored and things like that. And the wall around it had some stains and moss and whatever. And it looked very beautiful. And I took a picture of that. So it's not the original, it was the time and moss and whatever made it more artistic. So that, would that also be an infringement of the poster, because the poster has changed over time, that it doesn't matter?
No, remember the poster is only the physical embodiment. The copyright is separate from the poster.
Okay.
Right? So I assume that the copyright holder, it hasn't been dead for, I don't know if in Cuba it's 50 years or 70 years or what have you, but I would assume there's a high likelihood that there's copyright in the work. Yeah.
Right.
Yeah.
Yeah.
So
Thanks.
if you want to go and exhibit internationally or whatever, you know, it's possible that someone will come and say, hey, but that's my, you would still have copyright in your photo of the work. But the point is you could nonetheless be infringing the rights in the
person. Yeah.
poster. Yeah.
Thanks.
You're welcome. Right. So this is actually what we just were talking about. If you take a photo of a copyright protected work, it's a form of reproduction, or it's a form of copying, and you need permission. And I give examples. So if you take photos of sculptures, not of the, remember there's an exception for sculptures on permanent display in the public. So not those kind of sculptures, but you know, if you come to my home and you take a photo of a sculpture, or you go in a gallery and take a photo of a sculpture, paintings, toys, maps, fabrics, all of these are examples of works that could be protected by copyright. Now, importantly, it must be a substantial part of the work. So, I don't know, let's say, this is just random, this, which is really just a coffee used to clean my glasses, but it has a pattern. So let's say that, you know, there's copyright protection in the pattern, and you take a photo of one of the circles, just one of the, so you zoom in and just that one circle. Yeah, you've not taken a substantial part of the work. So you could get away with that. So you have to take a substantial, you have to copy a substantial part of the work. And that is tricky. So I just gave you the example of the little circle. I can't think of an example per se in terms of photos. But this question of substantial, it can get a little tricky. And I'll go back and use the example of music, because it's a well-known, it's something a lot of people ask about. If you sample a piece of music, there's a myth that says you can sample up to 8 seconds or 8 bars or something. And that is just a myth, because when the court has to determine what is substantial, it is going to look at the effect on the overall work. So using music, I'm sorry to use music as an example, but if you take 3 seconds that are very recognizable, very unique, integral, really important part of the work. It's only 3 seconds, but that could be treated as substantial. So in terms of a book, you have a book that is 5,000 pages. In that case, a chapter may not be treated as, you know, a 10-page chapter may not be treated as substantial unless it's really at the heart of the plot. But if it's just, you know, some chapter that really has visual value, it might not be treated as substantial. But it's different if you have a 50-page book and you take you copy a 10-page chapter. So the issue of substantial is assessed on a work-by-work basis.
A question, getting back to substantial, my understanding is if we took a picture of the public buildings and some time ago when Nelson was there, the whole of Nelson was in the picture, but the actual statue made up a very small part of the whole work. Would that be infringing the copyright of the statue, or would that, because it's not the major focus of the picture, they won't come into?
Right, so there are a number of things that come up. Nelson wasn't the best example because there's no more copyright in that work. Our work is too old. But let's assume it is a work that's more modern and protected. You have the exception for sculptures which are on permanent display in the public. Under our act, let me go back a bit. When I spoke about, when we started today, and I spoke about section 73 here. There are exceptions for buildings, sculptures, models of buildings, and works of artistic craftsmanship. Oh, sorry, I don't know why it keeps doing that. If permanently situated in a public place or on premises open to the public. So your example, and I suppose we could switch out the statue or say a painting. Let's change it to a painting that's on display temporarily in front of the Parliament building. The other issue that would be raised would be whether or not it could be treated as an incidental inclusion. So you would have to look at, was there a substantial part of the work if it was copied in whole? Yes. But was it an incidental inclusion? And you would have to look at the photo and the subject of the photo to determine if it truly was incidental or not. Your example is a little different from an earlier example where, you know, it was given where it was blurred in the background and so on.
Right.
In this case, if it is up front in the photo, it was not really the subject of the photo, but there would have to be a judgment as to whether or not it would be considered an incidental conclusion. And remember, these are assessments that will be made by the court. There is no black and white here. So it would be for the judge to look at it and to make a determination.
There's a statue at the Crane that I love to take. Beauties really love that statue, and it's out by the pool.
Mhm.
But would the Crane be considered a place open to the public, or was that a private place?
I think the Crane is going to be a private premise.
Right.
All right, in the chat, let's see. So if I take photos of a model in clothes, I had to get copyright licenses, I guess, permission for the clothes. We should bring up fine art, nude photographs. Oh gosh. All right, Tommy will get you from it. All right. We having some fun. Actually, that kind of, this is the last slide, I believe, and it kind of anticipates that. So let's go back. So, clothing. Clothing isn't generally protected by copyright. The drawings for the designs would be protected by copyright. But the protection of clothing in terms of copyright can be tricky. More than likely, you're going to be dealing with trademarks. So another form of copyright protection, sorry, forget I said that, another form of intellectual property protection altogether. So trademarks, and I believe I introduced the concept briefly last week. Trademarks include names, signs, logos. In some countries, it includes scents, as in how things smell. Essentially, these are signs used to distinguish your product from those of a competitor and as an indication of source. Where do these products come from? So, you know, Tommy Hilfiger would be a trademark, Ralph Lauren, what have you. It's a totally different system from copyright. But the point is, there are rights in the trademark. And often you will see, especially in television, in videos, they'll blur out the trademark. You actually need permission to reproduce the trademark of another that's owned by someone. And then this point here, where the photo is likely to cause confusion regarding affiliation. That is where consumers are likely to believe that the photo was sponsored by the trademark owner. So you take a photo of a model wearing Gucci, chances are consumers will think, you know, Gucci sponsored the clothing or something like that, or there's some association with Gucci. So unless you have a license or some sort of agreement with the trademark owner, you avoid taking photos, including trademarks, other than where there's an incidental inclusion, where there's a likelihood to cause confusion. And this is why, you'll watch a movie, someone is using a laptop. We all know it's an Apple or Dell or whatever, but they'll put a sticker or blur out the logo. So you have to bear that in mind with photos. There are other forms of intellectual property rights other than copyright that can exist in a work. So if there's a bold use of a trade, if there's a bold trademark present, you try not to use it. If there's another right called the industrial design right, I think I mentioned that last week as well, which concerns how products look, the design of products and so on. Some of them, like this chair, but there's some really, the point is you aren't ready to reproduce or to take copies of protected industrial designs. The question will be whether it's an incidental inclusion or not. So to sum it all up, you need to be aware of other forms of intellectual property rights and to ensure that you're not infringing those rights. The primary one of concern to you will be trademarks, brand names, for example. And what you want to avoid is a likelihood of confusion. So you avoid them as much as possible.
What was the situation during the Cricket World Cup here, where they was saying you had all sorts of restrictions of taking pictures, including other people's names or what addresses? What was the situation back then?
Well, I don't know 100% because they had sunset they'd actually drafted legislation specifically to establish the rights that they needed protected and so on. But that's why they would have had limitations in terms of what you could do once you went onto the grounds. So you had to be authorized to take photos, and then they would have had the limitations and so on in terms of how you could use the photos, etc. But I can't or don't want to be very specific because there was legislation put in place specifically to cover the World Cup and to establish rights that may not have or that may not generally exist, or to clarify rights and so on as it related to that activity. But with an event like Cricket World Cup, the Olympics, etc., they will have very specific rights established, and there are certain rights that exists for international organizations as well. They get specific protection for some of their intellectual property rights, but they will usually, if the legislation is not already existing, they will have some, it's practice, standard practice, you have sunset legislation to govern the event. So they would have stipulated how you could reproduce the trademarks of sponsors, who could reproduce the trademark of sponsors, things like merchandising agreements, the contracts with photographers, et cetera, et cetera. And really, we reached the end. So let me see what is in the chat. So we're still on with the naked models. So let's move on. In a few years, we can't take certain photos at all. Think we safe with sunsets. It isn't as extreme as that, Sean D. The thing is, you need to put your feet in the shoes of others, because where you own intellectual property rights, you want to be able to exercise them. It's not, you want to be able to exercise them and to be able to benefit financially and other ways from your work. And there's a safe expectation from others for the same. In the case of the trademarks, now, as I said, those are a different category of rights, and we aren't going to go into those at all tonight. Well, other than to say one of the reasons they're given those protections is that they make really big investments in developing those trademarks. Those are the brand names. So if you are Tommy Hilfiger, you would have made a lot of investments to build awareness of your brand, to build your brand reputation, et cetera, et cetera. Just as you as a photographer would have invested in, trying to take the work and get a nice image and so on. So it's not that it's so restricted that you can't go there and do your photography. But having said that, as much as I work in intellectual property, the reality is that there are efforts to tighten rights, to make the rights stronger and so on. And a big part of that has to do with what Charmaine is asking about the online or the copyright law. Sorry, I read it incorrectly, Charmaine. Yes, the copyright laws are available online, but the online environment is, and the ease of copying, and we're going to talk about that when we do the online, photos in the online environment, has made it really tough. So in order to try to protect their interests, the owners of intellectual property rights are lobbying and fighting to ensure that there's strong protection. But that's another conversation about how strong the protection should be and so on. All right, nudity in public places for the purpose of art is definitely an interesting legal topic. Yeah, I'm not discussing nudity in public places. Next, what happens to my normal pictures I put on Facebook if they're used by others? You're going to deal with online separately. Now, if you take some photos and you put them on Facebook, you own the copyright or they're copyright protected or whatever. The same rules apply in the online environment as in the offline environment. So people can't, just because it's social media doesn't mean that you suddenly don't have any rights. So we will not get into that today, but we will discuss that. And I promised I need to remember to download the terms for Instagram and or Facebook. So I will remember to do that.
I have a question.
Yeah.
That's my understanding of taking a picture. I
Mhm,
can take a picture of anything
mhm.
and keep it for my personal use once I do not publicly display it or whatever.
Yeah,
So that's
Yeah.
that's correct.
once, yeah, if it's strictly private use,
Right.
including the photo of the nudes on it with hands. I can't remember the name now. Yeah, you can, for private personal uses is always an exception.
I took some pictures. I was at Skeets Bay once and I saw these old people. Well, probably
Who?
my age.
You
Oh,
saw-
some people probably my age.
Okay,
They're old by now, right?
okay.
When they got by the sea, about 3 of them, they took off all their clothes, put the clothes in the salt meat container, and then they swam out to the boat, put on the thing in the boat, and climb up on the boat, and then
And
put
you took
on the clothes.
photos?
Yeah, of course I took photos. But that was my private use. I wouldn't even think of using it.
I don't know what the this group of photographers are about, but okay. No, but private use is an exception, yes. I think someone raised their hand. It's
Yeah, that's
certain.
me again.
All right, I'm coming to you just one moment. A certain newspaper took a picture off my Facebook. Yeah, not allowed, Sean Dean. And it goes back. Remember when I was going through the exceptions? I mentioned the fact that for current events, current affairs reporting, the exception where you can use copyright materials without infringement does not apply to photographs, right? So we will deal with online. So I really need to wrap up. So let's deal with this last. Who is it? Raise hand.
Me,
Alexander.
sorry. Yeah.
Yeah, go ahead.
I got one question about, let's say, okay, we talked about contracted as a photographer and copyright, and
Mhm.
is normally, is first belongs to who pays me. Okay.
Mhm.
So what about as an artist? I treat myself as an artist mostly as a photographer. I use a camera as a medium, but if I see a person and I want to photograph them as a muse, they're not paying me to photograph them. I'm photographing them as a subject.
Mhm.
Does the copyright stay with me immediately?
Yes.
Okay.
Sure.
Okay. Okay.
Mhm.
Just want to clear that up too. Mhm.
You had another question? I thought you had two.
The other one was more, I think I got that from what you were saying before in terms of, it was, my question was, does written agreement override the local copyright law?
So you're granted rights and they're your property and you can generally treat with your property as you want, with few exceptions. So, you know, if you're going to undertake an act of terrorism or something,
Mhm.
but generally you can treat with your rights as you want under contract.
Okay.
That's a broad statement, because as I
Right,
said,
yeah.
you know, you have other limitations.
Mhm, mhm.
All right, so it is time to wrap up. So I got the last video put on YouTube. I'll put this one. And I had a question about making the video available on your website. And I thought about it, and I would say just do a link. I really wasn't doing this in a very public way. I was just doing it for, I was asked it for a group, and certainly not for commercial purposes. But the reality is I do consultancy work, and I'm not paid a ton of money, but I would normally be paid to do sessions like this, or I could be paid to do sessions like this. So to do 4 hours, and maybe it'll come up to 6 or possibly 8 hours in total, is really a lot of material I am giving you for free. So whilst it's on YouTube and anyone can go and see it or whatever, I don't really feel comfortable, widely distributing. So I will try and I'll try and get it edited with that. But, and for reasons like that, it's supposed to be just a very intimate session. So I am willing to leave it on YouTube and to give you the links, and you'll probably share them or whatever, but I don't know that I want to make it an official public thing. When I'm finished, all of them, all the sessions, I will look at the material, because I haven't looked at the videos. I must say I don't really like looking at videos or photos of myself. So it's not something I've rushed to do, but I'll look at them and see how I feel about them. And then I might agree, okay, yeah, fine, whatever. But right now I would prefer limited distribution.
Erica,
Yes?
this is Hugh. We truly appreciate the effort and the commitment you've given towards us in actually facilitating this. It's something that we've been trying to organize. Well, the training team of the BPS has been trying to organize for about 5 or so years, trying to find the right resource or resource who would be the right person to give us the greatest step of information. And truly, I think we're blessed to have you do this for us. We really thank you and appreciate the level of preparation and the work you put into this. And definitely will abide by your guidelines as to however you want to have it distributed or not distributed or whatever, because we truly appreciate what you're doing here for us.
Okay, thanks. Like I said, I don't mind people having access to it, but I'll take a look at them, and so for me it was a really, really casual thing. So in terms of how I interacted with you, so I will make them available every week, and at the end I'll just look at them and see how I feel about them. But it's my pleasure. I quite enjoy it. I have to talk with Bradley and see when I will schedule the next session, which will be on the online environment. And I promise to have Derek Wilkie speak to you about the e-commerce site that he has, which thus far has been focused on the visual artists, but can include works of photography. And I said I would also see about getting someone from one of the organizations that, there aren't many, but one of the organizations that manages the rights of photographers, and they normally do it with visual artists, but to see if I can get them to do a little session with you. I need to organize that. The challenge there is to find someone in our time zone that can speak English pretty well. So I'm working on that. I believe it's possible though. Just know that you at least, I don't know that you're ready, but At least so you understand how that works. Yeah,
There are a number of us who work internationally, and it's good to have those contacts and that information because it's something that we're blind to right now. So if it possibly can be achieved, we would greatly appreciate it. Or if they can, if we want to see the direction of their website, that we can take a look and see what they have on there, that would also help.
I can always share some websites actually, but I don't think it's necessarily difficult to get someone to do it. It's just, like I said, the time zone. I will ask a colleague, she's in Brazil, and she may be willing to do it. She's in the right time zone and so on. I'll find someone from one of those organizations and at least let you see what's going on. All right?
That would be awesome. That would be awesome.
Mhm. All right, so thank you. I am going, my day started, I started work this morning at 6:30 and I'm ready to finish. So have a good night. And I
Thank
will,
you for tonight, Erica. Thank you.
You're
Again. Thank you again.
I'll speak to Bradley and organize the next session. All right, so
Thanks
take
a lot.
care.
Thank you.
Thank you very
Have a good
much.
night.
Usually very informative. Thanks. See you next time. Thanks.
All right, bye-bye.